Hi, my name is Tony Brown. I'm the senior family lawyer here and the director at K3. Alongside of me I have quite a large family law team, and we specialise in helping people work through property matters relating to periods that they may have had a relationship with another person. The Property Relationships Act is the legislation set down by Parliament that controls what is or is not a relationship when it comes to dividing property with someone that you have lived with and loved for a period of time. There's generally something called the 3-year rule, and that means that if you've been in a de facto relationship for 3 years, that the property that you have, whether you're married or not, obviously, will be shared equally. The main property that's shared equally after 3 years is the family home and family chattels. If you are married, the same rule will generally apply, although not so strictly. If you are in a civil union, the same rules apply as if you were married. Parliament has set down in the Property Relationships Act many aspects of how a de facto relationship should be defined. There are different types of things that are taken into account when deciding whether or not you do or do not live in a de facto relationship. A de facto relationship is different to just being a boyfriend or girlfriend, girlfriend and girlfriend, boyfriend and boyfriend. And de facto relationship must mean that there are some aspects of cohabitation and sharing. Those things can include bank accounts, sharing of a house, sharing the care of children, whether they are yours or your partner's, who does the household duties, who pays for them, how we own property and when that property was purchased, and also, quite importantly, how your friends see your relationship. Evidence is required of those different types of things if there is a dispute as to whether you were or were not in a de facto relationship for 3 years. It can be quite important after 3 years about the inequality of contribution. For example, if one person brings into the family a home worth quite a lot of money and the other party makes no contribution at all, you may wish to take some steps and talk to your lawyer about securing your own ownership of that, so that if something happens in your relationship, either you separate or you die, that there is some certainty about who should take that share of the property. We have a team of lawyers here who are specialised in this. If you are unable to decide or agree on how your property should be divided, the family court is your first port of call for making these decisions in the absence of agreement, and evidence will need to be called by you, your friends, your bank accounts, bank managers, and perhaps even extended family members as to how your property may have come about if you are not willing to share it, or if there is a dispute about whether you have been in a relationship for 3 years or not. Clearly there are lots of different ways people have relationships, and there can be some differences of opinion as to whether there is a relationship or not. And when you couple that with the very complex piece of legislation that is the Property Relationships Act, it can appear a little bit of a minefield. If there is any concern of that you have about how you could protect your property or share it with your spouse or partner, it's really important that you do talk to a lawyer who specialises in this and has a really good and clear understanding of the Property Relationships Act. My experience is sitting at around the 22-year mark of doing exclusively this work, and I'll be very happy, along with my team, to assist you to work through what is important in your relationship and how your property could be either preserved or shared in accordance with you and your spouse's wishes.